सुप्रीम कोर्ट में नागरिकता संशोधन कानून को चुनौती देने वाली याचिकाओं पर आज सुनवाई होगी। सुनवाई से पहले केंद्र सरकार ने सुप्रीम कोर्ट में सीएए को लेकर हलफनामा दायर किया है। इस हलफनामे में केंद्र सरकार ने सीएए का बचाव किया है। हलफनामे में अधिनियम को एक सौम्य कानून कहा गया है और कहा है कि संसद सीएए का मसौदा तैयार करने के लिए सक्षम है। केंद्र ने यह भी कहा है कि अन्य देशों में उत्पीड़ित नागरिकों को बचाने के लिए अधिनियम की आवश्यकता है और यह उत्तर पूर्व में अवैध प्रवासियों को प्रोत्साहित नहीं करेगा। तो ये जो केंद्र सरकार का हलफनामा है, ये उसकी डिटेल्स है। आज सुप्रीम कोर्ट पे इस मामले पे अहम सुनवाई होनी है। हरीश इस वक्त हमारे साथ फोन लाइन पे जुड़ गए हैं। हरीश, सीएए पर अहम सुनवाई होनी है कोर्ट पे, आज को क्या कुछ होगा कोर्ट में, बताइए।
Yes, that's right. After a gap of 2.5 years, the bench led by Chief Justice will be hearing around 231 petitions challenging the constitutional validity of CAA. The key petitioners, that is the Congress through Jairam Ramesh, Indian Union Muslim League, Jamaat Ulema Hind, Asaduddin Owaisi, Mahua Moitra, and a number of organizations from Assam and Kamal Hassan's party and DMK in their petition had contended that CAA is unconstitutional, discriminatory, arbitrary, illegal, and it singles out Muslim migrants and gives citizenship only to Hindus, Sikhs, Buddhists, Christians, Parsis, and Jains. So now, but the center, as rightly said, in an affidavit filed in the Supreme Court last night, has called the CAA benign legislation. Parliament is competent to draft it with citizenship coming in union list. Center also said the legality of CAA may not be within scope of judicial review, since matters of citizenship and foreign policy fall squarely within the domain of the Parliament, and this cannot be challenged through public interest litigations, and courts cannot interfere. The center also asserted that the CAA does not affect the legal, democratic, secular rights of the present Indian citizens, and at the same time, there was a need to save citizens persecuted in Pakistan, Afghanistan, and Bangladesh. The Modi government also blamed the successive government before it for not doing anything to protect the persecuted minorities in Pakistan, Bangladesh, and Afghanistan. The affidavit says, and I read out, treatment to be given to classified communities in particular neighboring countries has been attracting attention of successive governments, but no government took any legislative measure. And so, justifying the act, Center has asserted that doctrine of reasonable classification did provide for exceptions from equal application of law in certain situations. So, the Center is arguing that Article 14 may be saying equality before law and equal protection before law, but the Supreme Court has in several judgments held that if there is a reasonable classification of groups who form a class by themselves, then that legislation will be valid. And it says that here a persecuted group of 6 communities in Pakistan, Afghanistan, and Bangladesh, which are declared Islamic countries, form that reasonable classification, and CAA is not in contravention of Assam Accord 1985 or Immigrants Act 1950. So it is wrong to say it will encourage illegal migration into Assam and Northeast states. So we'll have to wait and watch what kind of order the Supreme Court will pass after going through the center's affidavit. Back to you.
Harish, I want to understand from you, because this CAA has been rather controversial. There is legality to it and there is political controversy to it. So put this in perspective for us. Why is CAA so controversial?
Yes, as I said, among the key petitioners, there are around 231 petitioners. Why is it controversial? Is because they call it unconstitutional, discriminatory, arbitrary, illegal, saying that it singles out Muslim migrants and gives citizenship to only Hindus, Sikhs, Buddhists, Christians, Parsis, and Jains. They argue that even Shia Muslims and Ahmadiyya Muslims faced similar persecution in these countries, but they have been wrongly denied Indian citizenship. And these petitions also argue that any classification based on a religious identity violates Article 14 of the Indian Constitution and secular principles. They argue that rules violates India's secular constitution, citizenship cannot be on the basis of religion, but only birth and descent. They question how religion can be a criterion for citizenship eligibility in a secular country like India. So these are the main arguments put forth by the petitioners, and now Centre has filed an affidavit. So let's see what stand the Supreme Court takes today.
All right, Harish, we leave it there. Keep tracking those developments for us. For the moment, thanks very much for joining us with those details.